This class will deal with acceptance in the context of the law of contract. There are several classes, in fact, in this series on acceptance, and this one will explore slightly different topics, different issues associated with acceptance. As part of the agreement process, acceptance takes place as soon as an offer has been confirmed. Contract starts with the offer, then the acceptance, of course there's consideration and intention. These are the four parts. But here we'll be just dealing with acceptance. But once the offer has been made and once it has been accepted, then the contract, generally speaking, comes into existence. It's important that an acceptance is clearly expressed while the offer is still open. So there should be no ambiguity about the offer or about the acceptance. Both should be clearly expressed whilst the offer is still open, before the contract comes into existence. Once the offeree has accepted the offer, a contract comes into existence in which both parties are legally bound. The offeror, the person making the offer, will accept in return the acceptance of the offeree. So both parties agree, the offeror and the offeree. Both parties agree, then a legally binding contract will come into existence. And neither party can withdraw at this stage. Unconditional acceptance of an offer. Well, it's important that both parties accept the offer unconditionally and are willing to be bound by certain terms and conditions. The different circumstances and conditions may come about through a counteroffer or battle of the forms. But let me go back to the original statement here for a second. Both parties should accept the offer unconditionally. If they don't, if one of them makes a variation in the acceptance, adds another term, then in effect a new contract has been put on the table. A new contract is being negotiated. The old contract no longer applies. So it's important that when a contract comes into existence that both parties have accepted unconditionally the terms of the contract. Let's look at counteroffer. There are situations in which the offeree decides to alter the original offer to suit their needs, in effect rejecting the original offer. This is known as a counteroffer, and the case here, the famous case here, is Hyde and Wrench. So what's happened here is the offerer has made the offer. The offeree, the person receiving the offer, doesn't like some part of it and has changed it and gone back with a variation on the offer. So in effect they have rejected the original offer. They have changed it. And the case here is, as I said, Hyde and Wrench. Let's just have a quick look at Hyde and Wrench. This was an 1840 case. The defendant offered to sell a farm to the claimant for £1,000. The claimant in reply offered £950, which the defendant refused. So the offer was for £1,000. The offeree, in this case the claimant, wrote back and said they would give £950. And the defendant, the offeror, refused. The claimant then sought to accept the original offer for £1,000. So the offeree, having offered £950, decided, okay, go the extra £50 and go for £1,000. However, now the defendant refused to sell to the claimant, and the claimant brought an action for specific performance. The claimant tried to force the seller to sell at £1,000. Now it was held that there was no contract. The defendant didn't have to sell to the claimant. There was no contract between them. There was a counteroffer made. The counteroffer was made by the claimant of £950, and that destroyed the original offer, so that it was no longer open. The contract had been changed. When the claimant offered the £950, that changed the contract. So coming back later and saying, okay, I will give £1,000, there was no contract at that point. The contract had been destroyed. So therefore the defendant could not be forced to sell at the £1,000. Now let's look at something called the counteroffer, beg your pardon, hide and range. Let's look at something called the battle of forms. In this case, a battle of forms occurs when organisations use standard form contracts with each other to settle an agreement. Now, in this case, there may be a toing and froing between each organisation of forms in the build-up to the agreement of the contract, and this may cause some confusions legally. This may appear to be small writing, so stop the video and enlarge the screen, or better still, just type in Butler Machine Tool versus Excello Corporation 1979 into Google, and I'm sure it'll bring up the details of the case in bigger detail. But for the moment, let's just look at this particular case, because we're dealing here with the battle of the forms to see what happens. Well, Excello in this case wished to purchase a machine from Butler. Butler sent out a quotation for £75,535, along with a copy of their standard terms of sale. So the quotation was sent out with their standard terms of sale. Now the terms included a price variation clause and a term that the seller's terms would prevail over any terms submitted by the purchaser. So this was a price variation clause. They could vary the price, and also that their variation would override any variation submitted by the purchaser. Now, as it turned out, Excello ordered the machine at the stated price and sent a set of their terms which did not include a price variation clause. Now, the first one had a price variation clause and said that their term would overwrite any submitted by the purchaser. The purchaser now accepted the price, but sent out their set of terms which did not have a price variation clause. Now the machine was delivered and paid for, but the Butler who supplied the machine sought to enforce the price variation clause and demanded an extra £2,893, but Excello refused to pay. Now it was held the offer to sell the machine on terms provided by Butler was destroyed by the counteroffer made by Excello. Therefore, the price variation clause was not part of the contract. The contract was concluded on Excello's terms, since Butler signed the acknowledgement slip accepting those terms. So, where there is a battle of forms, whereby each party submits their own terms, the last shot rule applies, whereby a contract is concluded on the terms submitted by the party who is the last to communicate those terms before the performance of the contract commences. So Butler had sent out the price and the price variation clause. Excello had accepted the price but sent out their own term which did not have a price variation clause. Now they were the last ones to operate, and Butler had accepted that. So when Butler then tried to exercise the price variation clause, it was overruled. The last one, being in this case Excello, the last set of terms rules. Now, acceptance. Well, acceptance of an offer can be dealt with in various ways. For example, an acceptance can be accepted orally, or it can be in writing, or it can be implied by conduct. However, an offer can never be accepted on the grounds of silence. So silence does not constitute acceptance. Let's look at the Feldhaus and Brindley case, 1863. In this case, negotiations were taking place regarding the price of a horse. The claimant eventually wrote, "If I hear no more about him, I will consider the horse mine at £30 15 shillings in old British money." Now the defendant didn't reply. It was held that although he had intended to accept and sell at this price, his silence could not constitute acceptance, and there was therefore no sale. Silence is not acceptance. It must be communicated. Acceptance by post. Well, we dealt with the postal issue earlier, but a letter will be accepted provided it is properly addressed and stamped. The letter is effective from the moment it has been posted, even if the letter gets lost in the post. The posting rule is only worthwhile if the offerer has demanded an acceptance by post. So the offerer must be looking for an acceptance by post. This all goes back to Adams and Linsell, 1818. The defendant wrote to the claimant offering to sell them some wool and asking for a reply in the course of post. In other words, by return of post. The letter was delayed in the post. On receiving the letter, the claimant posted a letter of acceptance the same day. However, due to the delay, the defendants had assumed the claimant was not interested in the wool and sold it to a third party. So the claimant sued for breach of contract. Now it was held. There was a valid contract which came into existence the moment the letter of acceptance was placed in the postbox. This case established the postal rule. This applies where post is the agreed form of communication between the parties and the letter of acceptance is correctly addressed and carries the right postage stamp. The acceptance then becomes effective when the letter is posted. So it's when the letter is posted that the contract comes into existence. Now, with instantaneous forms of communication, forms of acceptance through electronic means, telephone, telex, internet, email, the seller offer will only be effective once received by the customer. And I suppose ideally it should be confirmed as received. In Torres versus the Miles Far East 1955 case, the claimant sent a telex message from England offering to purchase 100 tons of cathodes from the defendants in Holland. The defendants sent back a telex from Holland to London office accepting that offer. The question for the court was at what point the contract came into existence. If the acceptance was effective from the time the telex was sent, the contract was made in Holland, and Dutch law would apply. If the acceptance took place when the telex was received in London, then the contract would be governed by English law. Now it was held, to amount to an effective acceptance, the acceptance needed to be communicated to the offeree. Therefore, the contract was made in England, because that's where the effective communication took place. And that really concludes these few slides on acceptance. These adds to the other videos on the topic that are also put forward in these course of classes. There are some sources that you may want to check out, and also the internet. As I said, internet has an excellent lot of material, it's an excellent source of material for law. Just type the name of the case into Google, let's say, and hit the return key, and you'll be surprised at what comes up. Lots of detail on each of the cases. But that concludes this class, so thank you for watching.